Aloha and welcome to E Hana Kako. We're a weekly program on the Think Tech Hawaii Broadcast Network. I'm Keli'i Akina, president of the Grassroots Institute, and if you'll allow me today to give a little more extended introduction, I'd like to share with you what E Hana Kako means. Everyone knows the very venerable saying, e pule kako. It's said in public affairs here in Hawaii. It means let's pray together. At the Grassroots Institute, when I took over in about 2013, the board was so wonderful to allow me to adopt a motto, and that motto is similar to e pule kako, let us pray. It's e hana kako, let us work together. We believe that the only path forward for Hawaii is when people work together for a better society, a better economy, and a better government. And there's no issue in which this is more important than understanding the sacredness of the past of Hawaii and its people and a vision for the future. And the nexus for this issue is the future of the Native Hawaiian people and the relationship to the rest of society. Today, I am privileged to have with us two gentlemen who are truly experts in this area. One is a professor of law at the University of Hawaii, Williamson Chang, and the other is Michael Lilly, who is an attorney here and a former attorney general. I do need to say at the outset, by way of disclaimer and to let you know, that Michael Lilly and myself are both involved in a lawsuit. The suit is Akina versus the state of Hawaii, which consists of 6 plaintiffs, of which I am one. Michael is one of the attorneys, and we're going to talk a little bit about that. But at this point, I want to welcome my guests to the program. Williamson, aloha. Welcome, Professor Chang.
Aloha to you, too.
So glad you're here.
I'm glad I'm here.
Thank you. And Michael, good to have you on the program.
Aloha. Great to be here, Keli'i.
Professor Chang, if you tell our viewers just a little bit about your background and what you do currently.
I was born and raised in Honolulu, went to University Lab School and then away to college and law school on the mainland. Came back almost immediately, clerked for a U.S. federal district judge, Judge Dickon Wong. And the law school was starting, and I got offered, I was very fortunate to be offered a position. I was very young, and I've been teaching all kinds of courses. I started by teaching corporations. I got very involved in water rights. I was hired as a special deputy attorney general to represent basically the Hawaii Supreme Court in the case of McBride versus Robinson, where the claim was the Hawaii Supreme Court, by its decision, had unconstitutionally taken the water from the sugar companies, and that was a long story. So I've been involved in water and Native Hawaiian rights, even though I taught corporate classes, and I've been there about 40 years.
Well, thank you very much for your service at the university. Appreciate that greatly. Michael, tell us a little bit about your background.
Well, I'm a fifth generation Kikioka Aina. This is my home. I spent 30 years in the reserve as a naval officer and retired as a captain. I was attorney general under George Ariyoshi, a great governor. I've been in private practice now for, I've been a lawyer for over 41 years. And I must have been in front of you, Bill, when you were with Dickey and Wong. I had many cases in front of Judge Wong back in the 70s and early 80s. A great judge. I miss him.
Well, gentlemen, I'm going to cut straight to the chase here with a question to each of you. Actually, I'd like both of you to answer about the state of Hawaii and its involvement in the sovereignty movement now. It has a little bit of history to it. The state of Hawaii had promoted the Akaka Bill at one time, which would have achieved federal recognition of Hawaiians as an Indian tribe. That basically failed in Congress. And then the state of Hawaii, through the state legislature, passed Act 195 in 2011-12, saying that the state could sponsor such a nationhood for Hawaiians. Now, at the outset, I want everyone to know we don't oppose Hawaiians organizing for governance. What we're concerned about is the state of Hawaii and the federal government. So here's my question. In the most recent effort, which is called Na'i Aupuni, in which the Native Hawaiian Royal Commission and OHA basically set about to launch this nationhood project, Na'i Aupuni was contracted as an organization called private that would take the money from the state, that would take the plan from the state, and then would execute an election and hold a constitutional convention or an AHA in order for those who are Native Hawaiian by blood as exclusive participants to establish a sovereign government. Let me ask you this question. At the outset, Professor Chang, is this a private organization using private funds or just private agency to carry out this, or is it a state action?
Well, I would say that it's pretty clear, if you looked at any other area of law, like criminal law, that the monies were coming from the revenues under state law from Crown and government lands that were given to OHA, and OHA funded this so-called private organization. In RICO or racketeering, that would be called laundering money.
So is that right?
Sure. I mean, that's how you launder money, is you wash it and you give it to another organization.
But the claim is that those monies don't really belong to the people of Hawaii as citizens per se. These are trust funds that are set aside for Native Hawaiians. Does that change your perspective on this?
Well, what percentage of that money is set aside for Native Hawaiians? That's one question. The other is whether it's set aside for Native Hawaiians, it's set aside under state law. So under the color of state law, that's the real test. The color of state law, you had the funding of an election process that was going to end up in a convention purportedly to create a governmental entity. And I would like to add one other thing, that there's a Supreme Court case called the Sharing case, that's ZCHERING, which says states really are not to be involved in foreign affairs, in the creation of foreign affairs.
So the creation of a non-U.S. government would be foreign affairs.
That would be problematic under the Sharing doctrine.
Michael, what are your thoughts on whether this is, as OHA and Aupuni claim, something that doesn't involve the state at all?
Well, let's make it clear that we understand what we're talking about. If it is a state-run election, and it's either state-run or it has state action involved, in other words, there's state all over it, then they are not allowed to hold an election that excludes people on the basis of race or on the basis of point of view, First Amendment. And if it is state action, then it's unconstitutional.
Now, when you talk about racial exclusion and point of view exclusion, you mean that in order to sign up and even vote in the process or participate in the convention, you have to have Native Hawaiian blood. And in order to participate, at least at the start it was this way, you had to affirm the unrelinquished sovereignty of the Hawaiian people. So you're saying that they don't have a right to do this because they're a state organization.
If it is a state-run election, they cannot do that. It's unconstitutional. But there's no question that this is state action. The state, with Act 195, set up the process that they would create a Native Hawaiian roll, and it would be a roll of only people who were descended from someone that was here before contact, that were here prior to contact. So it was racially established roll. The state legislature created it, and then they funded it to the tune of about $4 million to create this roll. And that whole thing was a disaster anyway, we won't get into that. But then OHA, which is a state agency, as the Supreme Court held in Rice v. Caetano, contracted with this supposedly private entity, Aupuni, and the Akamai Foundation, there's two organizations, to conduct the election of delegates to a convention. But it could only be people who signed up as part of either the Native Hawaiian Rolls Commission lists or additional lists that OHA transferred over. So all the lists came from state agencies. They were created by state agencies. They were paid for by state agencies. And then OHA agreed to pay an additional $2.5 million to conduct this election. So there is absolutely nothing about this process that is not state action. And therefore, because it excludes people on the basis of race, and also to some extent requires you to have a particular point of view, that is the unrelinquished sovereignty of the Hawaiian people, that is a violation of the First Amendment, and it's also a violation of the 14th and 15th Amendment of the United States Constitution.
Now, you stood before Judge Seabright in the First District Court, and you pled the very argument you have just put in front of us. Let me turn to Professor Chang here, with whom I've not had this conversation before, and ask you what your thoughts about that are in terms of Judge Seabright in First District Court. He basically said, no, our argument is wrong. This action by OHA or Aupuni is independent of the state. It's not state action. What is your thought about that?
Well, I was really quite surprised by the language. I was quite surprised by his insistence and how far he went and how far he had to go.
What was his claim, basically?
His claim was it was a separate agency. You've created a separate agency. The money loses its taint once it's given to a special agency. But that's not the idea of state action. Clearly, the creation of Aupuni was to avoid the claim of state action. In other words, OHA would have run the election otherwise. What my second thought was that in the lower courts and in the state courts of Hawaii, there seems to be a sympathy for the Hawaiian people and what they're trying to do. And this was a sign of a judge sort of bending what is usually a very strict understanding of state action to sort of allow Hawaiian people to hold something that he thought was going to be a democratic sort of exercise in politics. So I sort of, in a sense, warmed to what I thought were his intentions, but my legal training said, I've seen a lot of state action. This is clearly state action. And it's also the absence of state action where you don't apply the state campaign regulations and all that, that are unusual.
Well, unusual, you say, and so I'll turn to Michael here. What are some of the implications of the premise that what Aupuni is doing with this election doesn't fall under state or federal law? That, as Professor Chang mentioned, you don't have a state election commission, you don't have an ethics committee and so forth. What does it mean that they're carrying out business without any government oversight?
Well, aside from all of the dangers of a completely unregulated process where you have no credibility or confidence that what they're doing, even if it was legitimate, if it was, let's say it was a constitutional election, there's no, as I say, there's no election campaign spending commission, there's no oversight to ensure that the process is fair. But aside from that, even worse is that if Aupuni could get away with calling this private action, then what it is a prescription for anyone around the country by subterfuge to come up with a way to avoid unconstitutionality by a simple procedure. And the Supreme Court of the United States has been very careful to say it's going to cut through and get down to the heart, the meat of the coconut. What are they really trying to do there? And not allow them to use a simple procedure to avoid constitutional requirements.
Well, you make an interesting point here, and I'd love to come back to it after we take a short break. You said that there could be national implications.
There are.
That if indeed Judge Seabright's decision ultimately prevails, that there could be implications in terms of the forming of entities across the United States. We're going to go in 20 seconds. Would you agree, Professor Chang?
I think if you go back to the history of the 15th Amendment, this was well settled. States, right after the Civil War, were trying to get around the 15th Amendment. In fact, the Republic of Hawaii and the Provisional Government of Hawaii were in violation of the 15th Amendment. They had states, well, the Provisional Government had elections, and the Republic of Hawaii had elections, which you had to hold so much property, you had to earn so much money, you had to take a loyalty oath to support the Republic of Hawaii, that they were made fun of by the Republicans, by the Democrats, excuse me, from the South, and saying, like, you're the party of Lincoln. Yeah, what are you doing basically creating these poll taxes, barriers, when your party stood for the idea that race-based elections were wrong?
So we basically have a return to Jim
We
Crow
have
practices,
we
more
have
or less.
we have a reminder of what was one of the unfortunate errors.
Well,
parts
we're
of
going
our
to take a
history.
quick break and then come back and talk a little further. I hope you are as intrigued with my guests today, Professor Williamson, Chang, and Michael Lilly, as they discuss this issue as I am. And don't go away, because we're going to be right back after this short break talking about what the implications are if the Aupuni scheme succeeds here in the state of Hawaii. What does that mean for the rest of the nation? We'll be right back after this short message. Don't go away.
Hi, I'm Jay Fidel. I'm host of Hawaii, the State of Clean Energy, which is our flagship show, which plays 4 to 5 p.m. every Wednesday. And the supporters of that show are Hawaii Energy Policy Forum and Hawaii Energy. And luckily enough, we have representatives of both of them right here today to tell you more about what they think about the show. Sharon Moriwaki at my left is co-chair of Hawaii Energy Policy Forum, and she goes first. Sharon?
Thank you. Thank you, Jay. I'm so glad that we have this Hawaii, the State of Clean Energy. This was 2 years ago when we started this, and we have continued it because it's so important. And there's so many developments happening across the state. And we hope you'll tune in every Wednesday, 4 to 5. It's wonderful.
And Ray is Hawaii Energy. Ray, what is your thought about the same subject?
Well, I agree completely with Sharon that we are talking about every Wednesday, 4 to 5. We talk about some of the most important subjects that are affecting the islands now and into the future. Energy, clean energy, we need it. We often run into new ideas that we had not thought about before. We did just today, and I think we're going to have more of that in the future. So come on down and watch us 4 to 5 on Wednesdays, and we'll see what happens.
We'll see you then. Aloha.
Aloha.
Welcome back to the second segment of today's program on E Hana Kako. I want to tip my hat to the people at Think Tech Hawaii. Jay Fidel, the producer, oversees the production of about 35 hours of original content from right here in downtown Honolulu that goes out across the world. We say aloha to all of our viewers across the world, and we want you to know that you can find this program and all other programs that are recorded here at Think Tech on thinktechhawaii.com. Thanks also to our wonderful team of volunteers and staff. Now, back to a very important question for the future of Hawaii, and that is, what are the implications of this attempt by the state of Hawaii to create a race-based sovereign nation? Michael, you were Attorney General at one time and dealt with a lot of procurement issues. You've seen money being allocated by the state through the Office of Hawaiian, the legislature and the Office of Hawaiian Affairs, and ending up in the process of the Native Hawaiian roll, as well as Aupuni, the election, and the AHA. Are there any procurement issues here?
Well, there was huge procurement issues in the development of the Native Hawaiian Rules Commission, because they spent hundreds of thousands of dollars on sole source contracts without going through the procurement process, the purpose of which is to eliminate fraud and ensure you're getting the best price for a product. But they had 2 contracts for a total of $800,000 that the Native Hawaiian Roll Commission, a state agency, gave out to 2 entities, one to do a video and one to do a labeling, without going through bidding.
Well, we'll come right back to what you're saying here. I just want to give a clue to our viewers who may not be familiar. The Native Hawaiian Roll Commission is that agency that prepared the voter list that eventually Aupuni would use in order to conduct an election and then hold a constitutional convention. I just wanted to point that out. Let me go back to you now.
And they were charged by the state of Hawaii legislature. The Native Hawaiian Roll Commission was charged to create the Native Hawaiian Roll. And they got $4 million from the OHA to create that roll. And they spent that money on myriads of things, many of which violated the procurement laws of the state of Hawaii.
Now, there's been an additional expense of about $2.5 million to to carry out the operations of Aupuni,
The election.
and the Constitutional Convention. Would you were also a Deputy Attorney General, would you have any concerns?
I was also a candidate.
Oh, that's right. And as a candidate too, do you have any concerns?
Of course I have real concerns, and I guess I would sum it up by a big picture. It's like when Thomas Jefferson was writing the Declaration of Independence, he did not apply for a grant to write that declaration from George V. It doesn't work that way. I mean, the United States is a sovereign entity, and if the goal of at least some of the delegates in some of the candidates was a kind of sovereignty, independence down the line, it's pretty ridiculous to expect the United States to stand by while they fund a movement that is going to challenge their sovereignty and authority. It's just not going to be as easy as that. And so what you see in the 15th Amendment is the tool which stopped this from happening. And the tool is a tool that's sort of neutral, and it says something that basically we all agree with almost any other time of the year, which is race-based elections are inherently unfair. We don't use race as a means of dividing the people. And I think the question that's on the minds of the Supreme Court is that of race in diversity in academic affairs. And so what happened, I think, very quickly was it moved from Judge Seabright's finding a way to avoid state action to the Supreme Court just looking at this from 2,500 miles away and say, this is a race-based election.
How about that? And that brings us to a question I told our viewers we would deal with, and I'd like to deal with it before we get into the case itself, and that has to do with the implications. If there is success to the process that Aupuni is setting up to have a race-based nation developed from a constitutional convention of only part or Hawaiian blood people, what's the implication of that? And kind of tied into that is a question I think a lot of people have. What's the big deal? The government already sets up and acknowledges Native American Indian tribes. Mike, what would be the implication if we set something up here for Native Hawaiians?
Well, it's the Aupuni, if it was able to be considered not state action, creates a very simple roadmap for anyone to avoid the Constitution. Very simple. Now, the courts don't allow that. The courts don't just look at the form, they look at the substance. The Supreme Court says, we're going to look at what they're really trying to do here. And an example was, there was a U.S. Supreme Court case involving in the South, where in order to get around race-based avoiding race-based requirements, they created a party, an independent party was created in order to vet all the candidates for the Democrat election. It was purely private, but the outcome of that would be that the people coming out of it would have any blacks. And so the blacks were going to be iced out of it. So it was clearly race-based, but it was private because it was a private party. The Supreme Court said, we're not going to look at the form, we're going to look at the substance. And what this is really trying to do is to engineer an election that precludes blacks from participating in the process, and that's unconstitutional. Well, here you look at the substance. What is really being done here is they've used a very simple subterfuge. They created an entity called Aupuni, a private entity, to achieve an outcome that the state established. The state set up, teed it up. In fact, Aupuni told OHA, before it entered into there was a contract for the election, that it would use the state role. It would use the Native Hawaiian role as the basis for the convention. So it was a quid pro quo, up front, ahead of time. So there's no question that when you look at the substance of it, everything about this is state action. Anybody looking at it can see that. It's very clear, and the courts won't tolerate it.
And you believe that it would open the door for state action to lead to any number of aberrations across the nation.
No, you know, what could you? The Creoles in Louisiana could establish their tribe,
Or a religious nation.
or maybe religious, right? You could have all kinds of different entities. You could have the Mexicans in California. I mean, you could fracture the whole country by the simple expedient
Well, let me ask
of
Professor
calling it private action
Yeah.
when in fact it's state.
Professor Chang. However, there are people who say, what is the big deal? The federal government is already involved in acknowledging Native American Indian tribes. And so wouldn't this simply be along those lines of letting Hawaiians have that status?
I think that's a very good point, but Hawaiians are not a tribe. They weren't a tribe. They were Hawaiians. Well, let me start with the idea that they weren't even called Hawaiians until the 1920s. The word Hawaiian comes in, Native Hawaiian comes in with the Hawaiian Homes Commission Act and the need to create a race-based group that's going to enjoy this federal housing entitlement. Before that, in the debate on the joint resolution in 1898, the word for the people of Hawaii was Kanakas. They called them Kanakas. They didn't use Hawaiians. Hawaiians was also brought back in the 1978 amendments to the state constitution as a way of defining people by race. So the idea of race, a race-based culture, is not a value of the Hawaiian people.
Now, let me just interject that. If you're saying that it wasn't until 1920 that we began to use race as an 1920s as we began to use race as
Native
a
Hawaiians
definer
as a race,
for Native
yeah.
Hawaiians with the Hawaiian Homestead Act, that means that from prior to the Kingdom of Hawaii, then from the Kingdom of Hawaii, Kamehameha all the way through Lilly, we're dealing with a race. We're dealing with a kingdom that doesn't define Hawaiianness on the basis of race.
I think that's the whole point. In other words, the difference between Hawaii and a tribe is Hawaii was a nation state. It was the Kingdom of Hawaii. You were a national. You could be German, blah, 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 blah. You could be a denizen. You could be blah, blah. In other words, the idea of race was not part of the Hawaiian scheme of politics until the annexation and the need for the federal government to do some kind of reparations and restitution. So they invent, because they only want these Hawaiian homesteads to go to Hawaiians, they invent the small n, capital H, Native Hawaiian, and in 1978 they invent the capital N, capital H, Native Hawaiian, which is terribly confusing, but is what is the basis here for the idea of a race-based election, is to try to make Hawaiians look like a tribe.
So then if the state of Hawaii and the federal government create or affirm or recognize Native Hawaiians as a tribe, they're really doing that not on the basis of race, because there is no Native Hawaiian racial tribe. The precedent could be set then for acknowledging any people groups, any social groups,
Right.
any movements, regardless of the fact that they don't have a race basis. We could acknowledge almost anybody as a tribe. That would be something.
Well, one of my colleagues said what was going on here was as if the federal government had gone into the United Kingdom and said, we want to create a tribe of Anglo-Saxons. I mean, you create a tribe out of any group, even though historically they don't meet that definition of a tribe that was gathered together on a basis of proximity of identity and affiliation and race, and partially race, but not always race. You had black Cherokees, for example. And Hawaiians, I think the thing that galls them the most is to be called a tribe when that's historically just false. In other words,
Well, we've just got a moment before a break, but I want to turn to Michael here. One of the implications of a Hawaiian tribal-based kingdom that includes Native Hawaiians by blood only is that your ancestors who served in the monarchy, in fact, one of them, Michael, was the Attorney General, would be stripped of their citizenship if they were around today.
That's what makes the Aupuni illegitimate when it points to the overthrow as the premise for establishing this tribe, when in fact the monarchy was multi-ethnic. They did not discriminate against anyone on the basis of race. There wasn't even in their language. My ancestors were Scottish, and they worked for King Kalakaua and Queen Lilly. My grandfather, who was 100% Scottish, I remember he was born in 1885, so he was born in the Kingdom of Hawaii, and he told me very close to his death. I said, "Who is a Hawaiian?" He says, "I'm Hawaiian, you're Hawaiian." And he was a royalist. So if you look to the overthrow of the monarchy as the basis for establishing a Hawaiian nation, then that Hawaiian nation, by definition, has to be a mirror of that monarchy in the sense that it's multi-ethnic. It does not discriminate against anyone on the basis of race.
Well, Michael, during the break, I'm going to ask you whether you're a Whig or a Tory. When we come back from our break, what I really am going to do is ask Michael to lay out the suit that we're involved in partnership with an organization called Judicial Watch. Then I'd like to ask Professor Chang to give his thoughts on that, and we'll close with giving you the latest information on where that suit is going and what we're doing. We'll be right back with Ehana Kako on the Think Tech Hawaii Broadcast Network after this short message.
Aloha! Hello, my name is Patrick Bratton. I'm host of Global Connections here at Think Tech Hawaii. We broadcast live every Thursday at 1 p.m. We bring Hawaii to the world and the world to Hawaii, talking about international events and various things of interest to the audience. Please join me. I look forward to talking with you and having you get to meet some of my guests. Aloha.
Aloha, my name is Kaui Lucas. I am the host of Hawaii is My Mainland, here every Friday on Think Tech Hawaii at 3 p.m. I invite people who are doing interesting and inspiring things in our community to help us keep it local and keep it real. Tune in any Friday, 3 p.m. and also available on our YouTube channel and my blog, kauilucas.com. Hawaii is my mainland. Aloha.
Welcome back to the final segment of today's episode of Ehana Kako on the Think Tech Hawaii Broadcast Network. At the Grassroots Institute, we're committed to helping bring people together, to work together to build a better Hawaii through a better society, government, and economy. As you've been listening to Professor Chang and to Michael Lilly, I hope you've gained the kinds of insights that will help us to do just that, build a better Hawaii. I'm going to ask Michael Lilly to explain a bit about the suit that is taking place. There are 6 plaintiffs. I'm proud to be one of them, along with 5 others, of whom 4 of us are Native Hawaiian and part Native Hawaiian. 2 are not Native Hawaiian. And we're very happy to be in partnership with Judicial Watch, which filed the suit. Michael, tell us a bit about this.
Well, we filed a lawsuit on behalf of these 6 people, to get a decision that the whole process, the whole Aupuni process, was in violation of the First Amendment, the 14th Amendment, and the 15th Amendment of the U.S. Constitutions and the Federal Voting Rights Act. And the core of it is really 2 things. One is that in order to participate in the process, you had to affirm the unrelinquished sovereignty of the Hawaiian nation. And that's a violation of the First Amendment. You cannot tell a person as a condition to voting, imagine you're voting for the President of the United States, but you had to affirm some point of view in order to participate. That's unconstitutional. The 14th and 15th Amendment precludes discrimination and holding an election on the basis of race. Now, we had what was called a preliminary injunction hearing before the local federal court, and we sought to stop temporarily the whole process so that the court could have adequate time to review the process before it was too late. In other words, before the election was held, before the convention was held, and all this unconstitutional conduct would happen. We wanted to be able to stop that until adequate consideration of that could be made. Now, the local court said, no, he didn't find a violation of any rights, and so we took that to the Ninth Circuit Court of Appeals, that's the appellate court, and we asked the appellate court the same question. We asked them to enjoin this process for the same reason. The court denied it. So we immediately went to the US Supreme Court. And the first step was before Justice Kennedy, who is the justice who oversees Ninth Circuit Court cases. And very quickly, Kennedy, who is known as the swing judge in the Supreme Court, he issued an order enjoining the collection of the counting of the ballots and the certifying of delegates pending further order of the court. And within, I think, 3 or 4 days, we got another opinion from the entire panel of the United States Supreme Court. I tell you, this is virtually unprecedented. There's very few times this happens, that you get an order from the US Supreme Court on an emergency motion on a 5-4 decision, affirmed what Justice Kennedy ruled.
Now, I've been reading a lot of legal blogs, and a good number of attorneys, constitutional attorneys and others, are saying that that's a pretty good sign that the Supreme Court sees merit in the case itself.
Absolutely. It's a clear indication, and it's, when you get an order out of the US Supreme Court that says, do not count ballots, do not certify delegates pending further order, you be very careful what you do next.
Okay, now thank you. You've summed up the case nicely. What I'd like to do is ask Professor Chang about the response that has been made by Aupuni. That they've taken 2 actions since the Supreme Court issued that injunction. First of all, they pointed out that the injunction given on a Friday to take effect on a Monday mentioned only the counting of ballots and certification, but didn't say anything about whether more votes could come in. So the first action taken by Aupuni was to extend the election by 3 weeks. And the second action they took was at the end of the second week, they reversed that and instead decided to cancel the election whatsoever and to seat all of the contenders for a position of being a delegate, rather than hold the election, just seat all of them, about 200 plus, in a constitutional convention or some kind of function that they'll hold in February. What are your thoughts, Professor Chang, in terms of the way perhaps the Supreme Court might actually view this?
I've got to admit, although I might have sympathies on both sides, that this is one of the boldest things I've seen, which is, it's not about the race-based election. It's about a race-based process that produces a body, such as the City Charter Commission, a water district, a state legislature that's all one race. And therefore, then they pass a bill that discriminates against other races. It's not about the election as much as it's about the consequences of an election. So if the consequences of the election are, okay, we're going to have all 196 Native Hawaiians become delegates, well, that's like, okay, we only allow people who are white to run in this Mississippi election. Oh, the Supreme Court says it violates the 15th Amendment. Okay, now we're going to make all of them delegates in the state, or all of them representatives and senators in the state legislature, so we're going to have an all-white legislature. That is what the 15th Amendment was really designed to prevent, is the process by which you create a political body that can make law that is of one race and one viewpoint.
In other words, the fundamental principle that the Supreme Court is addressing here is being ignored by Aupuni.
In other words, the idea
not only ignored, being evaded.
Well, to say you can certify people by naming all 196 to be delegates is like saying all you need is one vote. I vote for myself. Everybody votes for themselves, and they all become. In other words, it's a sham process by which an election really was held.
Now, how do you think the Supreme Court will react or respond to this? How should they feel?
Oh, I know how they feel. Well, what you have is a split in the Supreme Court. Why? Because race is, at the moment, one of the most divisive issues in the United States, both in terms of the Ferguson and police conduct, but also in terms of affirmative action. So you have a split right down the liberal conservative line of the court, but there are 5 conservatives, and one of them, of course, is the key swing vote, Kennedy, who was so important in Rice versus Cayetano.
And did he actually write the decision?
I think he wrote.
He did.
He
Yes.
wrote right.
Yes.
And so to ask to ask Kennedy is a superb move.
That was our stroke of luck to be in the Ninth Circuit.
Well, it was a superb move. If Kennedy says it, and Kennedy has to say it in a way because they have to prove their case is going to prevail. They were seeking a preliminary injunction. Those are the hardest things to get. And so the hardest thing to get, Judge Kennedy is saying they get it, and he says no election, and by that I mean nobody gets appointed to be a delegate. And so you're undermining the whole point of the Supreme Court, and I think, in my view, on the border of contempt of the Supreme Court by holding a convention that is going to progress towards creating a governing body through a constitution or any other documents. So one of the things I really worried about was, should I be sending a letter as a candidate to the Attorney General of the United States, who's a little bifurcated in this sense, he's got a foot in each door, and ask him, would I be committing contempt if I signed up by their deadline of December 22nd to become a so-called delegate? They cannot do that.
You have a concern, a personal concern.
I have a personal concern of being an aider and abetter.
That's right, because you actually wanted to participate in this
I want to participate, but
constitutional convention, and there is
the Supreme Court is
now
saying it's unconstitutional.
a potential liability for you as a participant.
Well, I think people would go lightly on me in terms of punishment.
That's right, because you're just a lowly law professor who would know better.
I'm just a lowly candidate. But I think the principle is, the Supreme Court says this is a race-based statute, this is a race-based election, and you go and participate in it, well, isn't that aiding and abetting?
Wow, this
knowingly,
is fascinating.
Knowing that. And so I would say, gee, it would be wise for delegates to get an opinion from an attorney general who's got to represent both sides, you know? And get Loretta Lynch, and get an opinion saying, can they meet? I think the question of whether you meet is the key, because from meeting you create political instruments like constitutions and governing documents.
So it's not only Aupuni that has a responsibility to consider, it's also the participants in this process.
I think to a certain degree it's a matter of honor. And when you think of us, many of us are law professors and law students, we have an obligation of the appearance of propriety, not just doing what is legal, but of not violating what is the essence of a decree by the highest lawmaking body in the United States.
Well, this is so fascinating. We could go on and on, but I think you both raised some important questions as to some considerations that have to be taken in the future, and I'd love to invite you back for your further analysis as this unfolds. Michael, thank you very much for keeping abreast of the issue as indeed one of the attorneys, but for your information today. Glad to have you here today. Aloha. And Professor Chang, thank you for sharing. This has been very fascinating. I hope you feel like I do, that we've just begun to understand this issue, which has broad implications for the nation. A friend of mine, Hans von Spakovsky, who is an elections law specialist at the Heritage Foundation, has used the word balkanization to describe the potential impact of the success of the state in being able to establish a government without any basis such as a Native American Indian tribe. Indeed, that's what's going on in Hawaii, and so I'm very grateful again to the legal experts who've weighed in today and for their counsel and encouragement as we move forward. I'm Keli'i Akina with the Grassroots Institute. We're here every week on Ehana Kako on the Think Tech Hawaii Broadcast Network. We'll see you next time. Aloha.